Hello there, subscribers, and welcome back to the King's Chambers YouTube channel. I'm joined this afternoon by my good friend Stanzie because we just fancied a chat about planning enforcement on this cold, wet winter day. Stanzie, how are you doing?
I'm all right, Freddie. Feeling even better for the prospect of a planning enforcement chat.
Well, it's nice to catch up about these things from time to time, and I think you yourself has been involved in a reasonably significant case in this regard recently.
That's right, yes. I've been in the Court of Appeal on a sentencing case not so long ago, and I think you've been in the High Court on a planning prosecution challenge not so long ago as well. Isn't that right, Freddie?
Yes, that's right. Not too long before Christmas, I was involved in a High Court case. It was a case stated against a decision of the Magistrates Court to convict someone for breach of an enforcement notice. It had a slightly novel background, I suppose, which is how it ended up coming before the High Court. The individual in question was prosecuted for failure to comply with an enforcement notice. And for our purposes, I suppose the salient facts of that notice were concerned with the property in a conservation area. And within that conservation area, an Article 4 direction had been made in relation to it. This individual had carried out works to his property. If the Article 4 direction hadn't been in place, they would have been PD. He was then issued with an enforcement notice requiring to remove the works. There was no appeal made against that enforcement notice, failed to comply with it, and was then prosecuted by the council for breach of that enforcement notice.
And so what were the arguments offered by the respective parties, and why did the matter find itself in the High Court?
So the issue before the magistrates was that the defendant didn't dispute the breach of the notice per se, but what he did was allege that the council themselves couldn't prove the offence because they couldn't prove that an Article 4 direction existed, and they argued that because the council couldn't prove that, and the standard they needed to prove that to was the criminal one, they couldn't prove the offence. Now, the council accepted that they didn't have a document which was what you would call the original Article 4 direction, so they couldn't just go, right, here you go, here it is, here is the original Article 4 direction. And there's various reasons for that, but the council said, well, we don't need to prove that, and in any event, here is our evidence that relates to it, demonstrating that it does exist. So, for example, there was direct evidence from a planning officer, there was various records in relation to the advertisement of the creation of the Article 4 direction, and notification that had been given in relation to it as well. And what ultimately happened before the Magistrates Court was that the bench decided that the council had proved to the civil standard that the Article 4 direction existed, and that as a result of that, the offence had been proved against the defendant. The defendant wasn't very happy with that, and so applied to the Magistrates Court to state a case to the High Court. And for our purposes, the main question, there were a couple of questions, but the main one for our purpose was that were the magistrates right to hold that the requisite standard for proving that what was the civil standard?
And what did the High Court make of that? Were they satisfied that the civil standard was a relevant standard and that it was a matter that needed to be proved?
So what happened was the council decided to defend the prosecution, even though it's theoretically a challenge to the Magistrates Court decision. And the position, so I acted on behalf of the council, and the position we put forward was that actually, and the questions posed by the Magistrates Court didn't arise because what the appellant was seeking to do here was challenge the validity of the enforcement notice. And that's something that they're prevented from doing by the operation of Section 285 of the 1990 Act, which says that where a ground of challenge could have been run in relation to an appeal against an enforcement notice, you can't then rely on that in subsequent proceedings. And now here, what was being alleged by the appellant, or originally the defendant, however you want to call him, was that the council couldn't prove the existence of the Article 4 direction. In reality, what that was an argument that as a matter of that no actual breach of planning control had occurred, because it was right that if there wasn't an Article 4 direction, that the works that had taken place wouldn't have been a breach of planning control. So the reality is that that's actually a ground C challenge to the enforcement notice, that the works taken place of don't amount to a breach of planning control. And so the council submitted that it just simply wasn't open to the defendant to run that argument before the magistrates. And as a result, the question posed by the magistrates didn't arise. All that the council were required to prove was a breach of the enforcement notice. And ultimately, the High Court accepted that argument.
And I think, Freddie, for the benefit of our listeners, the case that you're referring to is the case of Zafar and Stoke on Trent City Council. And we will make a link to it available in the description box below via BAILII. Is there anything else that our viewers and listeners should note, Freddie? Any other points of note arising from the Zafar case?
I suppose there's 2 points I'd make. I think it's quite a useful case for just a restatement of the principles of what it is that you're required to prove in an enforcement notice prosecution. So if you're representing a council, or if you're even being prosecuted, if you go away and look at this case, it sets out quite a nice summary of the relevant statutory provisions, relevant authority, and just what it is that is required to be proved in an enforcement notice prosecution. It's quite a nice, concise restatement of that. Beyond that, I suppose there's an interesting point that arises from it, because the court concludes that in this case, even if it had been required to decide this, which it wasn't because of the decision made in relation to the validity point, that the council's evidence was actually sufficient, not just on the civil standard, but on the criminal standard, to prove the existence of the Article 4 direction. So if somebody was faced with an appeal to an enforcement notice on the basis that an Article 4 direction or some other planning document, whatever it was, didn't exist and therefore, or could be proven to exist, and therefore the breach complained of didn't arise, it'd be useful guidance in that context to say, well, if you produce these sort of documents, that'll be sufficient to demonstrate that it exists. So Stanzie, that sort of takes people through, really, if they go off and look at that case, what you need to do during the prosecution. I think your case, which you appeared on it in the Court of Appeal, deals with what happens then in terms of sentence.
That's absolutely right. And perhaps before I turn to that Court of Appeal case, I'll pick up a slightly earlier decision of the Court of Appeal. And it's a decision that I think is quite helpful because, as our viewers may well be aware, there's no offence-specific guidelines for planning offences. And so what that means is the approach to be taken to sentencing is to follow the approach set out in the Sentencing Council's general guidelines on overarching principles, and then to have regard to sentencing judgments of the Court of Appeal. In terms of what the kind of relevant factors might be in determining sentences as general points of principle, the case of Kohali in the Court of Appeal is quite helpful. And in that case, the court said that in deciding the appropriate level of fine by way of penalty, regard should be had to the appellant's course of conduct, disregard of planning controls and whether or not that disregard was related to personal financial gain, failure to comply with the enforcement notice, and consideration of how much opportunity and time there had been for compliance with that notice. Deterrence, unsurprisingly, is a relevant factor. Personal circumstances, age, and previous good character, where applicable, will also be relevant. The Court of Appeal in Kohali also set out some important points in relation to double counting and financial benefit, which I know is often something that is a point of concern for authorities dealing with this sort of case. Subsection 9 of Section 179 of the Town and Country Planning Act requires the court to have particular regard to any financial benefit which has accrued or may accrue from the offence, but the provision doesn't fetter the judge's discretion when sentencing. The court's obligation is to have regard to the financial benefit, but there isn't an obligation to order the full amount or even a large proportion of it. And that principle holds for prosecutions under the Town and Country Planning Act, but also for prosecutions under the Planning, Listed Buildings and Conservation Areas Act 1990, because there's an identical provision in Section 9.5 of that Act. Both of those provisions also proceed in the broader context of the POCA regime, or the Proceeds of Crime Act 2002 regime, which allows for authorities to assess the benefit received from criminal conduct and to make an appropriate confiscation order. That course of action can be pursued independent from any sentencing process that's carried out as a result of a successful enforcement prosecution. In Kohali, the Court of Appeal made clear that it will be wrong in principle to impose a fine in respect of financial benefit from the offence under section 179.9 if it has already been the subject of a confiscation order, because this would amount to double counting. And then, Freddie, turned to the case that you referred to, which is my recent Court of Appeal case of Bloor, the Crown and Bloor. I wasn't counsel in the Crown Court case for this matter, and I represented the prosecuting authority at the Court of Appeal stage, where the defence raised 3 points in relation to appeal against sentence. It might be useful just to briefly set out precisely what the case concerned. It was a case in which Mr. Bloor had purchased a house with a first floor extension, and that extension had been built without planning permission. When contacted by the authorities, he made his planning application, but that application was refused, and an enforcement notice was subsequently served, which required him to remove the extension and return the house to its former condition by early October 2017. He didn't do so, and on his own account, he started the works to remove the extension at some point in February 2018, and he didn't complete them until June 2019, some 20 months after he should have completed the works. He was fined £15,000 following a guilty plea in the Crown Court to an offence contrary to section 179.1 of the Town and Country Planning Act. In other words, the failure to take down the building extension for which planning permission had been refused. He raised, by way of his counsel, 3 arguments on appeal against sentence. Firstly, that the judge had erred in adopting a starting point which was twice the level suggested by the prosecution. Secondly, that the judge didn't have regard to the fact that the offence was not motivated by financial gain. And thirdly, that the judge failed to give adequate credit for a guilty plea. In relation to the first point, the wrong starting point argument, the court held that the statutory maximum was unlimited and there was no statutory minimum. It was therefore the case that the judge had an extremely broad discretion in approaching the appropriate level of fine. He was required under the Act to have regard to financial benefit, as we've already mentioned, and a starting point of £20,000 prior to credit was fixed, having assessed the seriousness of the offence. The court was satisfied that that was well within the broad band of outcomes that would be a fair and proportionate way to meet the objectives of punishment and deterrence in the case. The view of the prosecutor, the court also held, did not in any way fetter the judge, because the judge was under no obligation to follow that view, and he was obliged to assess independently the relevant principles in relation to sentencing. He had no obligation to follow the view of the prosecutor unless he happened to independently reach the same view, as long as he sufficiently explained his assessment, which the court held that the judge in the Crown Court had done. On the second issue, which was the question of financial benefit, and whether the judge had had appropriate regard to the fact that the offence wasn't motivated by financial benefit, the Court of Appeal held that Mr. Bloor was, if anything, fortunate in the approach taken by the judge, because the judge had considered the question of financial benefit and had not concluded that there had been any benefit or intention to secure a benefit. In fact, Mr. Bloor would have avoided a significant financial outlay if he'd succeeded in avoiding his obligation to comply with the notice. And as such, there was an argument, at least, that there had been some financial benefit in this case. And the Court of Appeal felt that the approach had in fact favoured the defendant appellant in that particular case, in that particular instance. And finally, in terms of credit for guilty plea, the Court of Appeal observed that the plea was entered at the first available opportunity, in the sense that it was entered as soon as the indictment was amended to charge the correct offence, but that prior to that there had been no earlier indication that the appellant would in fact plead guilty. The maximum level of reduction in those circumstances was in fact 1/4, and therefore the judge had not erred in applying a reduction of 1/4 to the relevant sentence. And so those are the 3 points of appeal explored in the case of Bloor, and I think they will be of some interest and assistance to our viewers.
Right, well, thanks very much for that, and thank you for joining me this afternoon. Like you've already said, Stanzie, we'll post the links to both of those decisions in the description to the video, and anybody who goes away and has a read of both of those probably has a fairly reasonable overview of the prosecution process on a planning enforcement notice offence. So thanks for that, everyone, and we'll see you next time.